Hi everybody, and welcome to the Balance Bill session for Fee University based on the provider perspective. The reason that we're having this FEU today is obviously one is to get a couple more of you who previously have not worked in any balance bill cases up to speed in regards to balance billing. There's a couple people here that are either A, working on balance billing cases a lot, like myself, Kelsey. Basically, Kelsey, this is your full-time gig, right? I mean, your full-time job is working on balance bill files. So we're going to share some insight in regards to how this works, which we went over last time, but more importantly for this session is what the providers are doing to try to beat us in these particular situations. So how it all started was we had an invite from, it looks like here, Thomas Force, the president of the Patriot Group. And this is their handout, which I'm going to go over. And this basically explains to providers and to members as well, members are patients, that if they get a balance bill letter, how to get their health plan to pay more money. If you notice, nothing in here tells the member, oh, you got a $300,000 hospital bill for something that took 8 hours? Here's how you fight the hospital or get them to lower their charges. It's simply, oh, don't question the charges, just go right to your health plan. Here's how you get them to pay more money. Pretty simple. So, and it's titled, Generate Revenue for Your Practice with ERISA. All revenue building for providers. Pretty interesting stuff. So, I don't know who it was that actually listened in on this. It was like espionage.
I did.
You did, great. So anything you want to add in, feel free to chime in.
We actually, we have all the audio, and it's on the drive, so if anyone's interested, let me know, and I can certainly...
And those of you watching this online, you're bored to death, we can make it even more interesting for you by we will have another link. There'll be 2 links in association with this FEU on our website. One is going to be the actual slides, which will be linked there, as well as the actual audio. So if you're really bored on a Sunday afternoon, on a nice sunny day, and you want to just learn about this stuff, that's where you would go. Okay, so we're going to start off with, really quickly, an overview of the process and how it all happens. So, how does balance billing start? Really simple. Patient goes to a facility. Everyone gets that. Now, patient walks in, it might be treatment that's emergency care, which is obviously a lot different than it's a planned, scheduled appointment for surgery, whatever it might be. So, what the first thing it says, it's called Claim Basics, it says here, to have the patient assign their benefits and rights to appeal to you, to the hospital. So they're telling the administrators, the first thing you want to do when that person walks in with their ID card is get that person to agree to assign the benefits and the rights to appeal to you. Can you tell me why a hospital would want, why this guy is telling hospitals to have the assignment of benefits signed over to the facility?
Well, they're not going to fight their own.
Now, I know you try really hard. You're a very good employee, but you're missing the boat on this one. You know why?
So they can deal directly with the plan?
They can do what directly with the plan? What do they want from the plan?
Bill, money.
Money. They want an assignment of benefits because the assignment of benefits allows the plan to get the provider to get paid directly by the plan. Are you understanding this?
Mm-hmm.
So, if I have a contract, you have a contract right now with FIA, our employee benefit plan. Okay. In reality, every time you go to the doctor, I'm supposed to write you a check. Are you aware of that? Every single claim, I have a contract, not with the facility, I have a contract with you, the patient. So I should be writing you a check. Why is it that the hospital is saying, get the assignment of benefits?
So the check goes right to them.
Why?
Yeah.
Why do they want the check to go right to them? Why do they want the check to go to the patient?
So that they definitely get the money, because if the patient gets it, they might spend it.
Bingo. They're going to spend it. We know they're going to spend it. It's so different than subrogation cases. They're going to spend the money. It's a fact. They will spend the money. So, I mean, if you got a check made payable to you, not to you and someone else, checks payable to you for $45,000. I don't know. That's a good weekend. So the point is, they want you to sign their benefits. And what happens every time you go to a facility, you do this. You might not know it, but you're assigning your rights every time you walk in. It says it right there on the forms you sign. Okay? In addition, they want the right to appeal. Why is that? Anybody? Jared?
Because it gives them a chance to appeal the amount that the plan has decided to pay them.
They're going to do a much better job appealing a claim than a patient will. A patient gets a letter. Okay, how it works is, claim comes in. Claim comes into the health plan. Health plan takes the claim, hires an audit firm, or has their own audit firm internally. They're going to look at the bill, and they're going to say, this is overcharged, 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 excluded from coverage. I don't cover this. I don't cover that. We deal with this issue every day. We send a check for, on a $100,000 bill, we send a check for $10,000. Let's make sure I don't forget that. Okay? Okay. $100,000 charges, we pay 10. What does the plan doc say in regards to appeal rights? How long does the patient have? Anyone in plan doc should be to answer this question. How long does a patient have to appeal a claim?
365 days.
Would you agree?
Yeah.
Ty? 180, typically. Randomly, you'll see 365. Typically, it's 180 days. 6 months to appeal a claim. What happens after that period of time?
You can't appeal.
You can't appeal any longer. Bingo. So, if the patient has appeal rights, and the plan makes this payment, there's a chance the patient never appeals. Therefore, appeal rights are gone. By the time the hospital gets around to realizing it needs more money, it's been a year or two that already are gone by. So, a hospital wants those appeal rights right off the bat so they can appeal payment within the 180-day period of time. Okay? Now, what else does this document say? It says here that 60% of plans are self-funded plans governed by ERISA, specifically the type of clients that we represent. What else it says is, consider asking the patient, check this out, in that form you sign, ask the patient to agree that the hospital may file litigation against the plan on their behalf. Whose behalf? The patient's behalf. Naming the patient as a plaintiff in such actions. What they're asking is, the hospital saying, hey listen, the plan only paid $10,000 on this $100,000 bill. Will you agree to A, assign the benefits to us so we get the money, B, we have all the appeal rights, and C, agree that we can sue the plan in your name to get more money. So if the patient, not the hospital asking for money, the patient is suing the plan saying, hey, you need to pay them more. Very interesting stuff. So that's all the kind of things they do literally the minute you walk into a hospital. So next time, if you ever, knock on wood, but I'm assuming everyone here is going to go to a doctor sometime, look at those forms they make you sign. Or even they make you sign the first time, and then it's eligible for every single claim that you ever go into that particular facility ever again. So check that out. So that's the first thing. Now, right here they talk about the fact that adequate notice, it says there are certain statutory rules and regulations that ERISA plans must follow when responding to claims and appeals. Adequate notice in writing for denied claims, providing specific reasons, and a description of any additional information. That's what the law says, okay, U.S. Code. Why am I bringing this up? What is the most important document that we have to make sure when you work on balance bill cases? What's the most important document you need to have?
Plan document.
I'm pointing to you because you're in the plan doc department. If you don't get the answer plan doc, every answer come out of your mouth should be plan doc, in my mind, because that's the department you work in. Correct. The plan doc is the key. You want to follow the terms of the plan. So, the way plans lose these balance bill cases is they don't actually follow the terms of the plan. So, when I initially paid the $10,000 on the $100,000, when I denied the other $90,000, I can't just say denied. I have to say why. And do it timely. That's the adequate notice. If I'm not following what the plan doc says, they get paid in full. Because I haven't followed the process internally. And I can be held, the plan can be held liable. Okay? So, this document, for the next 3 pages, more, 4, 5, 6, focuses on make sure the plan is following their plan. Very simple, okay? It says here, notice of the plan's benefit termination must provide not later than 60 days after receipt of the claimant's request for the view of the plan. These guys are smart. They're making sure we follow the terms of the plan every single time. So when you get a balance bill case, before you start working on the file, be sure that you look at what the plan did up until that point before we got the case to ensure they follow the process. What you're going to notice, a lot of times, guys, we're not talking about letters. Anybody here ever work on in the claim support? Or anybody ever work on a case before? Regular several cases? You have, okay? What typically, when payment is made on a claim, do they write a letter to the provider? What do they give to the provider with the check?
Explanation of benefits.
Would you say, Jarek?
EOB?
Very good. An EOB, explanation of benefits, is what? Explains to the provider, here's what the benefit is, here's what we're paying, here's what's denied. A lot of times those EOBs are wrong. What do I mean by that? On the EOB it'll say, claim denied as exceeding maximum payable under page 63 of the plan. You go to page 63 of the plan, there is no page 63. It doesn't exist. Because what happens a lot of times, they get lazy in their claim systems. They try to make one verb, they try to use one tagline for every denial, or they try to make them all the same. But as you know, working in the plan doc department, that many times, even though it's the same TPA, every plan might have a different definition of allowable expense, exclusions, etc. UNC, you name it. It's different. So, but they want to be lazy. It saves a lot of money too if they can just keep a consistent wording on every single one of them. That's one of the things that we advise our clients is how to write those EOBs and what specifically to put on them. Okay? So, the EOB is the most important part. Okay? It says here, I'm reading this. A plan administrator must provide the following: reasons for the adverse benefit determination, reference to, and this ties right into what you just said, Jarek, reference to the specific plan provision on which the benefit determination was based. In all your work and overpayments, what percentage of time do you think a plan or a TPA references a specific plan provision on how they decided that benefit?
Maybe 20%.
That's why we're in business. Very honest. 20%. And the people that know this stuff know how to beat us on these things. It's not even us. It's what I always say when I speak at conferences. Typically it comes down to just processing errors. Not even errors. Just following a process that is just faulty in the first place. So, that's what they want. It's very important that you realize what they say is the court will determine whether or not the plan administrator abused its discretion in making the adverse claims determination in an arbitrary and capricious manner. What does that mean? What's arbitrary and capricious manner? Anybody? Chris?
That basically means with no reasonable justification whatsoever.
If you have reasonable justification to make the claim decision you made, a court is going to allow it. Reasonable. Okay? You're not being obvious in your denial for obvious reasons other than what the plan says. A great one was MetLife v. Glenn, Supreme Court case, United States. MetLife denied a woman's, I forget it was a disability claim, almost positive it was.
I think it was too.
They never read the doctor's notes. This doesn't take, an hour of Law and Order to figure that one out. You don't read the doctor's notes as to why a woman was disabled and you deny her claim for disability. Probably not a good decision. I could see there where you are definitely not making a decision. You're making a decision that is arbitrary. Pretty clear. So any questions so far? So the way a plan can show that the decision they're making is a fair one is based on actual wording in the plan and some type of audit or some type of proof that what they're saying is provable, is proven. Okay. So what the factors are that a court will look at when they make the decision would be inconsistent reasons for denial. What does that mean? Inconsistent reasons for denial. Anybody? Yeah.
This means that they don't In other words, they're not uniform in the way they process or deny claims.
The hospital has proof that there are 40 patients. 40 patients had this procedure. 39 patients were approved. This one's denied. Oh, by the way, this one's black. Everyone else is white. Oh, this one, the woman is old. Or this one, the claim had a complication. So therefore, it's $300,000. The other ones were $50,000. Oh, it's denied. Any type of inconsistent reasoning or processing regards denial. That's why you hear a lot of times, I'm assuming anyone that ever worked in a subrogation case, you'll hear our clients sometimes say, I don't want to set a precedent. I don't want to tell this provider we'll do 20% off. Or this hospital, I don't want to tell this attorney we're going to do 25% off because he'll use 25% off every single time we have a case with him. That doesn't exist as long as you have a reason, a valid, actual reason why in this situation it's different than the rest. So if they brought up, and I've used my example, oh, you denied this one because the woman's black. No, I didn't. I denied this one because she was drunk. And drunk claims, people that are drunk, their claims are denied for illegal use of alcohol or for an illegal act. It has nothing to do with she's black. She happened to also be the only one of the 300 people on the plan that was in a car accident that was wasted at the time of the accident. Just happened to be black. Understood? So you can look at this two different ways. I mean, it's very simple, all right? Second, fail to provide a full review of a claim. How does that happen? Don't actually review the claim. You just deny the claim. Plan has no money. Let's say fee is self-funded plan. I want to deny your claims. Okay? This week we're having a bad week. I'm just going to deny every claim that comes in. I'll wait for you to appeal. You'll appeal within 180 days. Hopefully in 6 months, I'll have enough money in the bank to pay the claims. But I'm going to deny them all because I just don't have any money. You cannot write on an EOB, deny because we just don't have the funds. Does that exist as a reason?
No.
Good. Third, and probably the biggest one for our purposes and what's important to you, reasons why a court can say that you were arbitrary and capricious in your claim decision making is that you failed to follow proper procedures in denying the claim. We just went over that. Either A, your plan doc language is horrible and wrong and you followed it, or B, most likely your plan doc language is correct, you just didn't follow the process. Happens all the time. Now, everyone understand that? That's how that works on the initial claim decision. Next, how is a court, and they're saying this, how a court decides whether or not they're going to change your mind, whether or not they would make a different decision in regards to the claim. The court does what's called a de novo, Latin term, review, which means they're going to review the coverage determination without looking at anything else. It's basically a brand new clean slate review. So what a court says is, oh, the claim was denied? Okay. What they're going to do is look at the claim. They're not going to look at why you denied it. They're going to look at all the evidence again, start from scratch, and make their own decision based on all the information available to them. Can someone tell me here who else does that? Lunch on me tomorrow, if you get it right. If you get it wrong, you owe me, I don't know, give me a soda. Don't get it from Norma either, those are already mine.
An auditor?
Who, other than the court, does a de novo review on behalf of plans?
The fee.
Thank you. Lunch, you owe me a soda. You do owe me a soda. I'm not kidding. I want that soda today.
Can we argue that she did? That
An auditor doesn't do a de novo. An auditor in our industry does not do legal opinions. An auditor doesn't make opinion letters. An auditor decides on a claim what should be paid.
I'm just trying to save her a soda.
She's not going to get saved one. You got the answer right. And the reason I looked at you, Chris, is we just did this an hour ago. $1.4 million claim. Guy was drunk, went to the hospital. TPA's telling them, pay the claim. TPA put in writing, pay the claim. TPA's been our client for 2 years. TPA knows what we do. TPA comes to us after. Here's the interesting part, and if anybody heard me yell earlier when I said, she's lying to us. She's holding something back. Everybody hear me say that? I yelled out, she's a liar. Well, we get on the phone with her, and we find, well, why does she want us? Because basically, after we did the review, we said, these are obviously not covered charges. The guy's drunk, car accident, police report, citation, pled guilty. Illegal act exclusion in the plan. Not felony, anything. Ron writes a 10-page letter denying the claim. That we would, a legal opinion letter, a de novo review, that we would deny the claim. Afterwards, this she writes, oh, we think it's payable, blah, blah. I go, she's full of baloney. She's not telling us something. Well, what she didn't tell us was that she already told the hospital in a letter that the plan already agreed that they'll pay the claim. So what is she worried about? What? Her, yeah, but let's say she's not the one who did it. What is she concerned with? Why would a TPA be concerned that they told a hospital in writing the plan is going to pay $1 million in claims that we feel aren't payable? What could possibly happen? They will be sued for a lot of money. And I'm not going to change our opinion just because she's our client. I'm like, this is even a close one. But that's a de novo review. Basically, we do these every single day. What we do every single day, and on the balanced billing case, the reason I'm bringing this up is you should be doing this on every balanced billing case you get. The days of me giving Cindy send this letter out, template, send it out, which we did many times, those days are pretty much over because we don't normally get the same plans over and over again anymore. We get now balanced bill cases from so many different plans with so many different types of language and so many different processes, we have to look each one of them one at a time. That's why in many situations, when we first get a balanced bill case, before I write a single letter, before Kelsey writes a single letter, the first thing we do is go, yeah, your audit's wrong. You didn't have a right to pay $10,000 in this claim. You should have paid $80,000. Pay the $80,000, and we close our file. There is no balance billing. So before you work on a case, make sure that we should be working on the claim case and that we are right in defending what the plan did. Now, sometimes the plan did something wrong, but we don't think that the hospital knows about it yet. So we'll try to cover it up or fix the problem before they notice it. So it's important that you realize the number one thing you want to look at is the plan doc, because that decision on the $1 million claim came down to two documents. One was the plan, what it excluded, and two was a copy of the police report. That's all I needed. I didn't need anything else to know those claims weren't payable. Understood? Good. So they give a bunch of different case law examples here. Why a plan messed up. Here's an example. A plan administrator, TPA, may not fail to give a reason for a benefits denial during the claims process and then raise that same reason for the first time after the denial was challenged. So, great example for Jarek. OP. Claim, please reimburse us, claim denied. Doesn't say why. They write back, the claim, we're fighting this, we don't think that, we're not going to give the money back, here's why. The next time we respond, oh, the claim was denied because the guy wasn't covered.
Yeah.
The court says, Ninth Circuit Court, but this is across the country, you can't bring up an argument for the first time in the appeal. Every argument you got to bring up first. So it's not like when you're arguing with your boyfriend or your wife or your girlfriend and you're bringing up things after the fact. You got to bring it up first time. So in your first statement, bring it all up. And that's another reason why you notice when Ron writes a letter, and I always joke about it, Ron writes 10-page letters. Why? Ron puts, it's called, we even have one. It's called, if anybody looks in the N-Drive ever, what's the letter called? The kitchen sink. The kitchen sink letters, like the old Fiat kitchen sink. Remember? Before Desiree got involved? Where you would, Colby was here still? Just shout out to Colby. Keep that on the video. But you throw everything in the kitchen sink in there. So every possible argument you have, you put in that first initial letter, which is what we do typically in regards to our cases. So they understand that, and they look, providers and their representatives look for that as a reason to get around our denial, even though we're right. If you notice something, have you noticed something yet? A sort of pattern here? Nothing they're talking about is defending the actual charge. Think about it. This lawyer has not spent even 30 seconds saying, defend your charges because you have proof that what you charge is right. It's saying, look how they screwed up appeal. Look how they screwed up the denial. Look to see if they didn't mention something. Look to see if they didn't follow the process. Nothing here. It's almost like how to get away with overcharging. That's what it is. That's what this should be called. But it's important you understand. That's why you got to pay attention to detail in these particular situations. So, it's important that you guys understand you always have to render a reason behind every single claim decision that you need to. In addition, if you work on cases or you work on balance bill files or sub-row files, one of the things they're going to say is they want a full and fair review. That means a lot of things, but ERISA specifies specifically what a full and fair review is, and we have this language in our appeals letters. And that is basically any documents, records, or other information that's considered relevant to a claimant's claim. It's relevant if it was relied upon in making the decision. Can someone tell me something that that may be relevant in making a claims decision? Leanne. The plan document, Leanne. Very good. When Ron and I made the decision in regards to the $1.4 million claim, what else was relevant in making that decision? I know who's sitting in my office next. Police report. Right. Why was the police report vital?
Because you can see if there was no legal action.
Thank you. Good. What else in a balance bill case, other than a plan doc, my assistant will answer this, is relevant in a decision on a claim, other than the plan doc?
The audit.
Thank you. The actual audit. See, in order to make an audit, what do you need? To do an audit of a claim, you need a...
Playbook.
To do an audit of a claim, you need to actually have the...
Claim.
Thank you. You need the claim. So, a plan doc, a claim, and the audit is pretty much what you need in order to make a decision on the claim. Understood? So when you're working on a balanced billing case, if you don't have the audit, and you don't have the claim, and you don't have the plan doc, or any correspondence received from an attorney, back and forth, appeals, correspondence, letters, etc., how do you work on the file? You can't. Because you can't make a determination on a claim without those particular things. In addition, a lot of times when you work on a file, OP case, sub-row case, balance bill case, you will be told that pursuant to USCA Section 29, Section 1021A1 and 2, that the administrator plan is required to supply the participant with what, Leanne? The plan document. You're required to give a plan document. Does it say how?
Sorry?
Does it say how you are to give them a plan document?
The plan document does say that.
What does it say?
I believe the plan document says that the parties can have access to them in the office, and there are certain ways they can come get it.
Does it say that you have to mail that plan document via FedEx tomorrow? No. Typically it says it's available at our benefits office. So we are not required to mail them a plan doc. We are required to make it available to them, whether it's online, whether it's at their office. In the plan document, in the back page, typically it says exactly that. So when you hear lawyers say this, we're going to hold you to a $110 a day penalty for not giving us, take a step back and make them read the provision and then give them what the plan document says. But feel free to share a plan document because in my feeling, the plan document is our biggest friend. It helps us on these particular situations unless you're trying to do something that's not in the plan doc. An example of that would be where the plan doc says, let me give you an example. The plan doc will say the usual and customary amount is whatever the PPO rate is. And then when the provider wants to get their PPO rate, and you go, oh, no, it's too much money, but that's what the plan says, you might have a problem now. The plan doc is your enemy, not your friend. We don't do well when the plan docs are enemies, our enemy in these situations. So, that's their whole case, guys. His whole entire session was on that. Now, what we have done is we've taken on clients. The first client that we are looking at here is, let's say, Caprock. Caprock is a TPA in Western Texas, located in Lubbock. Lubbock, Texas is the home of Texas Tech University. Okay, I've had the pleasure of going to Lubbock many times. And what they did was, they're a very innovative TPA. They're a TPA that has their own PPO network. The guy that owns the TPA, in my opinion, is maybe the smartest guy in our industry. Probably the smartest guy in the industry. Especially from a TPA standpoint. I mean, he's the kind of guy that you want as a partner or to work with. So they came up with the Cost Plus program that we are the legal backers of. What do I mean by that? We, FIA, created and set up their program for them. So what we did was we created all the documentation. We created the letters. We created the process. We created the education pieces for the members, explaining to the members how the process works. We created the ID cards. We created what the EOB language should be. So everything, we created a plan. So everything we know already with this particular company is right because we did it. Very different than most balanced bill cases we get. Most balanced bill cases we get, we've never seen the plan doc. We have no idea how this TPA processed the claim. And many times we can make an argument that they just messed the whole thing up. They didn't even follow the terms of the plan. With this program, we know that they are following a specific process, that they paid for a flat fee up front for us to design everything, and then we get paid on an hourly basis only at the end when all else fails. When they've tried everything internally, they try to resolve it in-house, they've done whatever they could, it gets sent over to us. So, we got our first case from them today. Can someone tell me when I got the first case from them, and when you guys start working on these cases, what type of documentation in the email, Leanne, what are we expecting to have attached in that original email?
Well, we have the plan document already on file.
One.
Because we know it.
We have the plan doc on file. Good. What else will we expect to have from them?
Here we have the bills from the hospital. I believe this is actually the EOB.
We have the actual bills. We have the bill. That's one thing. We have an actual bill. Okay. What else do we have? We have a balance bill letter. We actually have a creditor collections letter. A letter from a collections agency telling the patient, pay us $4,095.35. So that's a collections letter. So we got that. Plan doc. The actual bill. The bill is not, when I say the bill, I'm not talking about the bill the patient got. I'm talking about the bill from the hospital to who? Leanne.
To the plan.
Bingo. To the plan. We got the bill. We have a collections notice, which is what? Everyone here has received a collections notice. Maybe you guys aren't old enough, but I used to do Columbia House. Remember those? You get 12 CDs for a penny. Okay, I used to do it all the time. I used to use other people's addresses. And I would go, I would know like an old lady that was next door. I would send in the 12, the penny, and I would give an address, and then the CDs would show up, and I would just go to my neighbor's house, take the CDs, and then they would send out letters all the time. But it was my name, but the wrong address, so I could just argue that one, I'm a minor. A minor, you can't have a binding contract with the minor. So I used to get 300 CDs for free. I mean, that's how I built my whole CD collection growing up, was Columbia House. Because I knew I was going to be a lawyer, so I knew the legal ramifications around it. So I received from them what? Collections letters, which is very different than the bill. The original bill, which I have here, is a bill for $6,711.46. That's the bill. They are balance billing the patient $4,095.34 from the hospital to the patient. for a $6,600 charge, balance billing $4,000. Okay? What else would I get? Possibly.
Usually the explanation of benefits.
We have the EOBs from who?
From the plan.
Bingo. You guys are on fire. We have EOBs from the plan itself. This is the plan's EOBs. This is the plan saying we got this. So what happens first? Plan is created. Patient goes in facility, blah, blah, blah. And I'm assuming when they go into the facility, do we have a copy of, yes, I do, the ID card that we created. Patient walks in, they have an ID card. There's an ID card with the plan dot. The guy walks in, they have an ID card, they get treated, the bill goes to the plan. So ID card's 2, the bill is 3. The plan pays the bill using an EOB, which is what?
An explanation of benefits.
Bingo. And it says here, we got your $6,000 charge, we're paying you $4,500 on it, we're going to pay you $1,400 on it, and the reason why is here. The what? What am I looking for?
The denial reason?
Bingo. Message. Exceeds the maximal, I'm reading this to you guys. This exceeds the maximum allowable charge as per plan document. Right there. So it says everything in here in regards to what that plan document language says. That's all we're going to pay. And what do? Provider, what do when they got that EOB? The EOB came with what? A check. What did the provider do with the check? How do we know that? How do I know that?
Bank statement?
How do I know that? Simple. How do I know it? Anybody? Yes.
They billed the patient the rest of it.
If you saw that they paid $1,700 and the bill was $6,000 and the balance bill on the patient for the difference, means they deposited it. Okay? So we have the plan doc, the ID card, the bill, the collections letter, the EOB, and then the collections letter. And the collections letter was sent April 30th and says, you received care at this particular facility. Oh, hold on. Right. Here's the process, blah, blah, blah. You got the care, etc. They're appealing the claim. Letter was sent out saying, I received treatment at your facility on February 28th. We want to do a review of my accounts. Here's a letter under Fair Debt Collections Act. So what we did is, after this happens and the patient, all this happens, and finally the hospital appeals the claim, there's a whole new set of letters that we've put together in regards to how the appeals process is handled. The first person, there's 3 different entities involved, right? Well, there's 4. There's the TPA, there's the plan, there's the patient, and there's the hospital. We need to make sure that every one of these parties is on notice. So that's why when we typically do balance billing letters, what do we typically do, Kelsey?
Send them to
We CC the other parties that are involved. Good. So we want to explain to the patient what? What do we want a patient to know? Cindy, what do we want the patient to know? When they get balance billed, what do we want the patient to know? What are they supposed to do if they get balance billed?
call you.
Call who?
Representative. You.
If you got a balance bill FDL,
Yeah.
who would you contact?
Linda.
I would hope so. Right, and what's Linda going to do?
She's going to call the.
She's going to see me. Okay, good. So we got that squared away. But you're right. You're going to contact too the plan. So we're telling the patients, hey, if this happens to you under this program, the first thing you got to do is you got to contact your plan or your CAPROC. Then CAPROC on their own is trying to resolve the claim. CAPROC is going to basically do the following. They're going to tell the provider, you got what you're supposed to get. This is all the plan pays. The plan has a plan document that says specifically how much they're going to pay. If you, hospital, feel that you're owed more money, prove it to us. We're following the terms of the plan exactly. We're not doing anything else. We're going to follow the terms of the plan. Then they have to come back and say, all right, we deserve more money. And here's why we would deserve more money based on the terms of your plan. Maybe they have some proof that the surgery they did, the procedure they did, cost more than what Caprock found it to be. How does Caprock figure out what it's going to pay?
Their plan document.
How does that? All right, but the plan doc says we're going to pay what the reasonable maximum allowable amount is, 150% of Medicare, blah, 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 150% of what the cost is. Where do they get that information from?
My experience, pricing companies.
Bingo. Audit firms are the ones that can give them that information. So they have auditors, internal, pricing companies, cost plus companies, Medicare pricing online, etc., to figure out what should be paid. Bingo. Then, when they send the appeal, when the appeal is received from the provider, Caprock would then send a letter to the facility telling them what? The plan is self-funded plan. The plan has a duty to be what? You know the plan, Doc. What duty does a plan have to be what? Begins with a P.
Prudent?
Who said that?
We'll
Prudence.
talk about that soda after.
No, you slow me the soda. That has nothing to do with soda. Plan has a duty to be prudent with plan assets, right? ERISA imposed a duty upon the plan administrator to operate the plan prudently and in strict accordance with the terms of the plan document. To do otherwise would be considered a breach of our fiduciary duty. Who made up those words? Right there. So, you have the language in there figuring out this is what we found. We found various overcharges, blah, blah, blah. This is all we're going to pay. If you got a problem with it, you can appeal a particular claim. We'll take a fresh look at the particular claim and see what happens. Usually at that point in time, the providers stop. Okay, we don't want to fight this. They got a point here. Or they could appeal it back to the provider, or back to the plan. Or what else could they do, Derek?
Continue to pursue the patient.
Balance bill the patient. That's the easy way out. Because remember, the plan has a duty to be prudent with plan assets. With a cost plus program, there is no contract between the plan and the hospital. There's no contract. The patient has a plan doc that says, this is what we're going to pay. Patient goes to the hospital bills the plan pays what they think is reasonable. They want to be prudent. If that hospital doesn't agree, they always have the right to balance bill the patient. It's a fact. Because no one has agreed up front how much that hospital should get for what they did. So, if I go to the hospital, knock on wood, for a broken left arm, when I walk into that facility, before I get treated for my arm, I don't have a handshake, I don't have an agreement, I have nothing with that doctor who's fixing my arm, how much I'm going to pay for that cast. Unless what? I have a what?
PPO contract?
Thank you. Getting really good. If I have a PPO contract, it already know how much. That's why you have a PPO contract. It says, we may not tell you how much we're going to bill you, but we're telling you you're going to get 30% off of something. We don't have a PPO contract with Cost Plus. So what happens is, when they send a bill for my broken arm for $5,000, $100,000 to the plan goes, hey, we think $10,000 is all that should be paid based on all this information we have. $10,000 is very fair. Medicare would reimburse you $5,000. We'll give you $10,000. They always have the right to bill me personally for $90,000. And that's what happens in some of these situations, is they balance bill the patient for the difference. Now, what do they know, Kelsey, when it comes to the patient? What do they know?
They'll probably end up paying some of it. They'll just keep,
That what?
they'll pay some of it and then they'll go
If
back
I wrote
to
you a
the
bill
plan.
for I know how much you paid.
No, I
If I wrote
wouldn't.
you a bill for $90,000, you're paying that bill?
No,
Why not?
because I don't have that money.
You don't? What do you have $90,000? I thought you were just doing this for fun. So why did they balance bill you $90,000? What do they want me to do?
They want you to go back to your employer and complain.
They want Cindy to go to Linda and complain. They want Cindy to be petrified that she's going to lose her house. They want Cindy to be petrified that she's going to refinance her house or buy her dream home next month, and she can't do it because it's going to ruin her credit. It scares her way more than it scares Caprock or me or anybody else. They want to petrify her. They want to petrify you. They want to petrify this poor patient, Miss Pamela Kirkland here. Take that out. They want to scare her. They want to get her to go to the plan to pay more. But the plan is obligated not to pay more. They can always balance bill the patient. How do we get around that? What do we here at FIA do to help Miss Kirkland, to help the plan members, and to help the plan? What do we do on their behalf? What do we try to get done?
Negotiate. We try to negotiate.
The first thing we do is not negotiate. What's the first thing we do?
Tell them to contact you and self-balance.
The first thing we do is tell them, do not balance bill the patient. Right now this claim is in dispute. You don't have the right to balance bill the patient in dispute. You have to deal with us first. First thing we want to do is get them off Cindy's back. Why? Because Cindy's the biggest pain in my butt. No one is going to cause more harm to me getting this claim completed in a proper fashion than her. She's the only one that can call every day, wonder what's going on with my claim. Miss Sparks. That's who she can be. What's happened to my claim? What's going on? I got a refund next month. My husband, he just lost his job. She's the one that can ruin everything. I need her off my back. I need the hospital off her back. I want them to realize, stop dealing with her. Deal with me. Claims in dispute. What else do I have as an argument? I got 501R. What does that say? If it's a non-profit hospital, meaning most hospitals in this country are non-profit. This is not the Cancer Center of America. This is a regular hospital. If it's a non-profit, under the law, they are allowed, when they balance bill a patient, there's new rules in effect based on our beautiful Mr. President, of how much they can actually get and how they can get that money. They can't say, pay me in 30 days. They have to give you basically 2 years to figure out even if you owe the money. And at the end of the day, and I'm not going to get into all the details, but at the end of the day, under 501R, in the letter that we send out, it tells them, just so you know, even if you're right to balance bill a patient, all you're able to balance bill them is the maximum of what?
Medicare.
What you get from Medicare for the same treatment. So when I told you on that $90,000, on $100,000 claim, Cindy, what did I say Medicare would have paid on that one? We paid 10. What did I say Medicare would have paid? 5. Guess what? They received 10. Do they have the right to balance bill the patient then? No! They should be paying us 5 back. So the point is, we need to explain to them, you want to balance bill the patient, 501R says you already got paid too much. Stop. Then we deal with them. And what do we tell them? Either A, you accept what you got because it's already more than what you should get. B, if you want to balance bill the patient, what do we want to do? It's to revoke the what? Ron talks about this day and night. If I'm his wife, I must go nuts listening to this argument. What is the argument that Ron loves to bring up? We will revoke your assignment of benefits. Which, if you look on the ID card, what does our ID card say? It says on the Caprock program, and what did they say? What did they say? What's the first slide the lawyer brought up? What did he say you want to get every time a patient walks in?
Assignment of benefits.
And guess what the back of this card says? We are good. I'm sorry, but we are amazing. The back of it, we are. What does the back of this card say? Assignment of benefits. When you walk into that facility with your ID card, it's not this big. Here's what it says. Assignment of benefits is accepted as consideration in full. Meaning what?
You accept the card and you treat them, whatever we pay you is payment in full.
And if you cash the check, you acknowledge it. Plan does not utilize the PPO network. Payment is based on Medicare plus something, where no fee schedule exists. Plan will utilize standards listed in the applicable benefit plan document. Acceptance of assignment of benefits constitutes waiver of provider right to balance bill the patient. You can't do better than this. I mean, we're even saying, you take this money, you accept the assignment of benefits, you waive the right to balance bill the patient, you accept the patient in full. Please see the plan doc for more details. But sometimes they still do, because they still want to scare the patient. They maybe hope the patient will pay them more money. Sometimes the patients do. But at the end of the day, we have the right to revoke and rescind the assignment of benefits, where we can say, all right, man, you want to keep this going? Okay. But $10,000 we sent you on the $100,000 bill, send it back to us. Because if they revoke Jared, I'm going to go to you because I know you've been doing really good today. If I ask them to revoke the assignment of benefits, so they allow them to get the $10,000, if I revoke that, what am I asking them to do?
Give you back the money and bill the patient.
Give me back the $10,000 so I can give it to who?
The patient.
So what I'm saying is, okay, I'll revoke you don't want to accept this payment in full? I'll revoke the assignment of benefits. Give me that $10,000 back, and I have the obligation to give that $10,000 to the patient so they can bill the patient for the whole $100,000. And now they won't see anything. They already got 10. Now they got 0. So that's the revoking the assignment of benefits argument, and that's why we have that on our particular cards. If that doesn't work, let's just say worst case scenario, and it's happened 1 out of 350 times. They sue the patient. Patient gets sued. What do we do? Anybody, throw it out there. You want to get the soda off your chest?
Negotiate?
It's 2 sodas. I'm negotiating now. Now they sue the patient, and I have everything under my case.
Sorry.
You always I'll take the soda back. Okay, I'll take it off. And here's why. You always can negotiate. You always have the ability to negotiate, and that's the thing when you work on a balanced billing file. Depending on the client it is. One thing I didn't bring up, I'm happy with the word negotiate. Because I didn't want to talk about negotiation, you guys, right off the bat. I want to explain to you what the rights are. At all times, no, there is a negotiation aspect out there. Why? Why do I always have the ability to negotiate these claims? Anybody? Jared, you want to take a poke at it? Why do I have the ability, in every single one of these situations, pretty much, to negotiate some type of payment?
Because they want their money, so they'll take things. Like, you can negotiate it because they don't want to have to go after the patient.
Why is the plan willing to negotiate? Why is the plan giving me authority to negotiate? Not the provider. Why is the plan willing to say, not you, him? Why is the plan willing to negotiate? Why is the plan telling me, why is Caprock saying, hey, Adam, you got to pay another $5,000 on it at the end of the day, make it go away, make it go away? Why? Why would they say that to me?
Because they want it done.
Why?
Because the patient's going to get angry.
Why else?
Maintain the relationship with the provider.
They're paying me. I'm getting paid $300 an hour to work on these files. Every time I work on a file, every letter I send, every time I call, everything, they got to pay me. So if the patient gets sued, they got to pay me to go to court, defend, this, that, negotiate. You always have the ability to negotiate to make the claims go away. It's not a lot of money, unless it's a bad plan. Sometimes you have really bad situation, not the Caprock situation, where you go, listen, we should be paying $100,000. If I can get them to pay 80, if I get them willing to accept 80,000, you should. So every case is different negotiation ability depending on the circumstances. So you always want to keep that in the back of your mind. So if a patient gets sued, you always have the ability to negotiate. But at the end of the day, if a patient gets sued for $100,000 on a claim where I told you, is the plan trying to screw over the patient? No. Is the plan trying to lowball the provider? No. The plan is saying, we're paying you a reasonable amount based on all these other factors. When the government pays a claim on Medicare, I want to make sure this is vital to you guys. Understand this. When your grandparents or anyone you know that has Medicare, when they go to the doctor, when that hospital gets reimbursed through Medicare, the hospital is getting paid what the hospital said it cost them for the treatment. The government doesn't tell the hospital what it's going to get reimbursed. Every year, every hospital, every facility, every doctor has to tell Medicare what their cost of doing business is. So it's like I would have to tell the government, if I was Medicare, for instance, if FIA was a hospital, we spent $7 million last year. Okay? $6 million. I would have to say, I spent $6 million to run this place, not to make a profit, not to buy food for the fish, not to buy plants, not to buy lunch for you guys, not to have a FIA forum, not to have volunteer day. So the cost of running the company, chairs, desk, lights, salary, the cost, that's what they get reimbursed. The cost. So when I'm giving them what it costs them plus 50%, that's a 50% profit. I'm giving them way more than what it cost them to perform the service. So the argument that we use in court is when they sue a patient for damages, when they sue for $100,000, anybody here have been sued before? For anything? Anybody? I have. Okay. No one has been sued. You guys are awesome people. You get sued. If you watch, all right, you watch Judge Judy? You guys watch those stupid judge shows on TV? Maria, whatever her name is. I don't know the other one. The lady, Judge Maria, I think. I don't know what the one is. Anyways, what do they ask for when they sue? When the person sues their neighbor for smashing their windows in a car at a party, what do they have to bring?
Proof.
Of,
Damages.
which is, how would I prove? If I'm suing you, Cindy, for $1,000 because your little girls broke my windows in my car, what would I have to bring? Pictures of my car. And what else? How do I know it's $1,000?
Like what it costs.
I got an invoice from Giant Class. Proof what it cost. When a hospital sues a patient for the $100,000 and $90,000, what do they have to prove? Prove what?
That's how much it costs.
They have to prove that they owe $90,000. So when they bring the bill, you owe $90,000. What is the plan going to give the patient? Cindy's kids come and smash my windows to my Audi. I go, Cindy, I'm suing Cindy for $27,000 for the cost of the windows being replaced. Cindy comes in, go, listen, my kids did it. My kids don't like Adam. They hate him. I always talk crap about him when I used to be his assistant. They all hate him. They come over here and they want to throw rocks at this guy. Adam's car's worth $20,000. Howard's windows worth $27,000. Here's his invoice showing I owe $27,000. I have another invoice showing another competing bill that his windows can be fixed for $300. I want to pay $300. Case closed. I paid $300. You win. That's how it works. So when they sue for $90,000, we tell the patient, make them prove their $90,000 in charges, and that's when the hospitals buckle, because that's public information. How do you guys know it's public? How is a lawsuit public information? You can find it online. Look up the word Boston Medical Center lawsuits. I'm sure you'll see 20,000 of them. You ever want to go to a doctor, look up malpractice cases. Google it. Just like you Google pizza. You Google that. And it's going to tell you every time the guy's been sued. So a hospital would then have to show how it came up with its rates, which is called its what? You get this right, it's lunch. How does a hospital figure out its rates? It uses a what? 2 words. Lunch. Kelsey.
The usual custodian.
Come on. Jared.
Charge master.
Bingo. 2 lunches. He's on fire today. Charge master. And a charge master is if you read the Time Magazine article, if you listen to anything we talk about, if you read my articles, the charge master is the most intellectually, it's held in. It is the most secretive document any hospital has. How they come up with their charges. They don't want to share that. So in court, they walk away. They don't want to show how they can prove they charged $700 for a box of syringes that you can buy at Walmart online for $3. Case over. So at the end of the day, many times, we want them to go to court. If you listen to what I said in regards to this whole PowerPoint presentation, it never talks about validate your charges. Be proud of what you charge. Stand up and excited about what you're charging. You have the right to charge this. It says get around it with a technicality. Our job in the CapRock program and all the work that we do is to make sure there's no technicalities and make it at the end of the day that if they want to get their money, they have to prove that what they got is fair. And the reason why, in a lot of cases where you work on, Kelsey, you wonder, why do you negotiate? Why do you make deals? How come you're making deals in these cases? And every single case that you've worked on up until now has a network. Every single one of these cases that we work on with Armed Group and all these other TPAs, even when the hospital thinks it's out of network, every one of them is in network. Why? Lunch. Why are they all in network? How is it that every single one of these claims is really in network? And that's why we're making deals, because at the end of the day, I can get shown, it can be proven, that every single one of these claims, what the hospital should be getting is exactly what they're charging. Why? When that person walks, now you're not getting lunch, but when that person walks into the facility, what are they showing them?
Their cards,
And what does that card have on it?
the network.
It has the network logo. So when they look at it and go, oh, that's the multiplan logo. We have multiplan. It's already their network. They are already, because of that network, we have a contract with the network that says we're going to pay you X% every time. It doesn't matter how much they charge. They can charge $100,000. It says, I'm going to give you 20% off. So without thinking, I'm supposed to write a check for $80,000, even though Medicare would have paid $5,000. And why do people have networks? The same reason why all of you have a network here at FIA. If you have health insurance at FIA, you have access to which network? Blue Cross Blue Shield. Why did I do that? Because 9 out of 10 of you, when you go to the doctor, you're not going to a hospital. You go to a doctor, a physician for whatever little things you need done. And those bills are $300, $500, $200, $1,000. So we have a network for you so that you don't get balance bill $30, $50, $100. You could go to the doctor, he's in your network, they take the card, you pay your copay, it's small money, it's no big deal. But the problem is, what doesn't exist is you to have a network of just doctors. It doesn't exist because the hospitals own all the physicians' offices. If you notice, maybe when you were kids, like when I was a kid, I went to Dr. Kristen King, he's on Broadway in Southie. He was a little office, he was a Greek guy, and he was by himself with a little lady, and then you go in there and he was your doctor. Dr. Kristen King is now would be part of the Atria healthcare system or the Granite Medical Clinic in Quincy. They're part of giant organizations that are all owned by who?
The hospital.
Bingo! So if you want to have a network for your gynecologist, your whatever, you also have to have pregnant women's, children's, Tufts Medical, all the hospitals in it too. So that's why you can't have your cake and eat it too. You can't have a physician of doctors and then we're going to pay the hospitals because Cindy, knock on wood, will go to the hospital once every 2 years. $100,000 bill. Okay, we'll negotiate that one and we'll help you in the balance bill. We can't do that with her because she also wants me to take her little girls to see the doctor every 6 months. So that's how this all happens. But this Cost Plus program works for Caprock because what did I say at the beginning about this guy, Dave Adams?
His own PTO.
He built his own network. He built his own network of doctors. So he's able to offer people, you want to go to see the doctor for your physical? You can. But when you go to the hospital for surgery, Cap Plus is going to be in place.